Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in our case number CACV 190242. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. But if you do so, as you know, just keep track of your own time. These proceedings are being audio and video recorded, so introduce yourselves if you could, and who your client is. I guess we're now live streamed, so you can check it out on YouTube as well. We have read the briefs, discussed the case at conference, and are familiar with the arguments. So with that, let's move forward.
May it please the court, my name is David Abney. I'm here representing Stephen Barsell. The basic proposition that I'm going to try to convince the court is correct is that if someone at a public entity tells you that a certain person occupies a position such as secretary, twice tells you on two different occasions, that you would be justified in leaving a copy of the notice of claim addressed to that secretary or the organization with a functionary there, be it a receptionist or a secretary or clerk or somebody of that nature.
Is there a case in the last 15 years that stands for that proposition?
I do not think so. Other than, I think it's a logical extension of Lee versus State. The original Lee versus State, the one at the Court of Appeals, the holding was you have to have actual delivery to the appropriate person, hand it to the appropriate person. And then in Lee versus State,
happen here.
No, that did not happen. But then Lee versus State at the Supreme Court said, well, you can mail it, and indicated that other forms of service would be perfectly fine. You don't have to hire a process server. I could, for instance, if I had to serve Judge Weinsweig and I came and I dropped it off at the clerk's office, that would be acceptable. Or mailed it to the clerk's office with his name on it, that would be acceptable.
And how do you say that as though it's a truth we should all just accept? How do you get there?
Well,
Judge Weinsweig is Judge Weinsweig. He is not the Court of Appeals. How would you serve somebody else other than him?
Well, I should have said if he were chief judge, and then I would leave the clerk addressed to the chief judge, and then with the expectation naturally that in the real world it would get to him very quickly. If you mail something to somebody, as in Lee versus State, mail it to the Attorney General's office, the presumption is that whoever picks up the mail, whether it's a mailroom clerk or a secretary or receptionist, whoever, will get it to the appropriate person. And here, twice, the process server was told, well, our secretary is Ashbury.
So you're making a suitable age and discretion argument. Really?
In a fashion, yes, of course. Even if it's somebody of unsuitable age. I mean, if it's somebody that you know is going to get it to
11-year-old employee of a public entity, but has suitable discretion.
If there were such a person, yes, Your Honor.
I have to say that it doesn't seem that the Supreme Court has been heading in the direction you are, and one could fairly say that the notice of claim procedure is intended to be a trap for the unwary and a barrier to lawsuits, and debate the policy of that, but that seems to be what it is.
Well, it often seems that way when you're on the other side, when you're on the side of people who are trying to get a notice of claim to the appropriate public entity or public employee, that it is a trap for the unwary. But it's also supposed to be a system for the rapid and proper and equitable adjudication of claims. And here in the real world, if you're going to drop off a notice at an office and the secretary says, "I'll take it for boss X," you expect it'll get to boss X.
I've never seen any statement that the notice of claim statute is designed to achieve justice or the just resolution of claims. The most aspirational thing I've ever seen said about that statute is that it enables, gives parties an opportunity to settle before litigation.
Well,
But everything else is very matter of fact, fairly dark. Just a statement that strict compliance is required, and we don't really care about the just result, which again you could debate, and it could be troubling to a lot of people. But that seems to be the state of the law.
well, and I've handled any number of these notice of claim cases over the years, maybe 20 or I don't know, an awful lot of them. And they seem to go off the rails on the most insane things. This, for instance, you would expect the process server to be a little more diligent, but the process server was reassured twice about that you can drop this off here. That this is the secretary is Ashby, and this is the proper way to do it.
Counsel, I see a lot of discussion about service on the chief executive officer, and you argue that a general manager is akin to a chief executive officer. But is service on the chief executive officer permissible or enough here? Is this an H4 case or an H3 case? Meaning, is this a municipal entity or, quote, other governmental entity?
This is an H4B case.
No,
The one I have says 4.1 H4.
H4, right, okay.
And it
So
serves-
what I'm asking is, why is this an H4 case rather than an H3 case? Why isn't this a municipal corporation, a municipal entity? Rather than, so four is a catch-all. So 3 says we have 3 different types where we're going to require specifically X, Y, and Z. And the third one is a municipal corporation. And then we go to 4, which is catch-all. To me, this looks like a subsection 3 case, especially given ARS 482901, which says exactly that irrigation districts are municipal corporations.
I never viewed it that way, Your Honor. I viewed it as a district with a board, like a school district. And I suppose that if it fits within the category, if it fits within that definitional category as a municipal corporation, then that would be the portion of the rule of procedure that you would follow.
So we don't necessarily have to indulge your arguments about general managers and the like.
No, although I wish you would. I mean, a general manager is the equivalent of a chief executive officer, and the rule was amended to say chief executive, and then had the S in parentheses after it. I assume it means chief executive or chief executive. It's chief executive officer or chief executive officers.
Right, but again, that's subsection 4.
Right.
Not subsection 3. Subsection 3 is the clerk. Do you know who the clerk was here?
The clerk would, I believe the clerk would be the same as the secretary under these circumstances. They never served a clerk. They were trying to serve the president, the secretary, and the general manager as in his role as a quasi chief executive officer.
Do we know if they have a clerk?
I never saw anything about them having a clerk, a formal clerk. It's a very, maybe my co-counsel can explain this more fully, but pardon me, the counsel across the aisle can explain this more fully. But it's a hard organization to research on the internet or otherwise. If you look around for it, it's very hard to figure out who's running what at that outfit. And that was one of the problems that the lawyer had.
Let me just ask, because you said you'd like us to consider this an H4, but the other side is the Maricopa County, I can say it, the Maricopa County Municipal Water Conservation District. How do we ever consider that as an H4 and not as a municipal corporation?
Because it's a district with a board. That's how I looked at it, as equivalent to a school district.
Is there any case that suggests we look at it differently because of it having a board
No,
or anything in the statute?
no.
Okay.
This organization has been sued before and has sued, but I couldn't find any case like it involving this particular organization.
So if we accept this as a municipal corporation and that your client needed to serve the clerk, really all we need to focus on are your three equitable, your estoppel and waiver, and then your third argument, which was tolling. Is that
Essentially, yes, sir.
all right?
Yeah,
And rather than sort of the definitional arguments about who is who.
Correct. And in that regard, when you go to an office and you're told twice that a certain person holds a certain position at that office, and you leave the papers for that person, that position.
Is that enough in regular civil litigation?
Well, I cited
Let's say
two federal cases indicating that it was. It seems to me that it's fairly enough. I mean, it's the idea, I mean, setting aside notions of the fairness of this whole notice of claim process, but part of this idea, if you're trying to give them notice so they can investigate, allocate, pardon me, I've got the bug now, allocate funds and settle, then you want to make sure that it gets to that office, and that's what happened. The notice got to that office, handed to a person who said the second time, yes, Ashby is the secretary, and I'm going to take this.
Which is a perfectly reasonable, practical position. I'm just not sure it's supported by the law.
Well, it's time
And
to
it's-
light a
it's
candle, I
unfortunate.
suppose.
What?
It's time to light a candle then, I suppose. I mean, if it's a bit murky, and it is, I'll admit that,
All of our candles are 2 floors up.
well, they can either light another candle or they can snuff it out. I don't know, but
Well, isn't the reality equitable estoppel against a government agency and based on government contact is different than private? And we make it harder to establish an equitable estoppel argument against a governmental agency.
yes.
Okay.
But here you've got pretty strong testimony about what happened.
Well, but we don't even have a name of the first representative. It's an
No.
unnamed. So what's the strong testimony? That I spoke to somebody?
At that office, an employee at that office, and that employee said X, Y, Z.
The
And
arguably self-interested testimony of processor.
That's
who was
always the
paid
problem.
to serve process.
Well, and that's really how the Lee versus State case wound up at the end. It became a question of fact that went back to the court to decide. And in the end, I think the case actually settled before anything actually got decided. But the directive to the court in Lee versus State was, was their service. And then they were supposed to investigate and determine
So
one way or another as a question of fact.
So let's move to that then. I don't see anything in the record to show that there was actually strict compliance or that there was some person with apparent authority, undisputed apparent authority, who might be able to trigger a doctrine of waiver or estoppel. But Arizona case law pretty jealously guards the lack of authority that most employees have to create an estoppel or to make a binding representation. So how do we get around that?
But if you talk with somebody at that office who says I can take this document, and by the way, in answer to your question, Ashby is the secretary. I can take this document. Why can you not rely on that person? They have all the trappings of authority. They're at the office working there in the receptionist or secretarial capacity. You would expect that they'd be able to say, well, I know who the secretary is, and I can certainly take this for the secretary. Otherwise, you have to
But
chase.
do we know? I mean, the problem I have is we don't even know that there is a secretary, apparently, right? We're going to rely on your colleague for that information. But if we don't know that there is a secretary, and in the vernacular, secretary has a very different meaning than it does under the rule, do we expect that anybody called a secretary is going to be able to accept service of a notice of claim?
No, there is an official board secretary.
I think Judge Swan is clerk.
Oh, I'm sorry. I apologize.
If we're using that.
I thought you were equating clerk and secretary, and so I thought that person was a mystery.
Well, no, in the sense of someone who would function in the capacity of a clerk for an organization, the clerk up at the top. The secretary here would be the equivalent of that. There is a district secretary, as far as I understand things. We thought it was Ashby, and they say it was somebody named Conklin. But there is a board secretary, which would be the equivalent of a board clerk in the big sense of the word.
You thought it was. This is a government board, an irrigation district. Is that memorialized anywhere?
Not in any place you can find easily. I mean, the problem with these cases always comes down to you could always have done better. No question about it. They could have done much better. And they didn't. So
Is-
was what they did good enough is really the
Well,
bottom
but
line.
that's not the standard. It's strict compliance, and it's not someone else's job to help you identify. It may be a little more difficult to find who the secretary is, but doesn't the law say that's the job of the person who wants to serve this?
Well, in a way, I hope I'm answering this question right on point, but strict compliance can be something as me going down and handing it to somebody or simply mailing it. That's strict compliance.
But to the right person.
Correct. But,
And
or to
isn't
the
it your
right
job
position.
to find out who that person is?
It would be very helpful. Absolutely. But
So if you had just sent a letter, dropped it in the mailbox, and just on that first line wrote, clerk, under your argument, that's sufficient.
clerk of the board, absolutely. Absolutely, as long as it's mailed.
Just
Now,
drop
there-
that in so you didn't need a process server.
No, you don't need a process server. I mean, I could do this. I could hire the 11-year-old to drop it off at the office as long as the 11-year-old actually does. I could sit in the car, watch the 11-year-old do it.
actually says person has to be 18.
Right. Well, for process serving, but for here, no, there's no requirement. You can mail it. You could have your pet Labrador take it to the mailbox. It doesn't matter. As long as the mail goes out, then you're okay.
Well,
it doesn't
and it's addressed to the right person, right? If it's addressed to the chief executive officer, no.
well, it would be helpful if it at least it needs to have the right position in there.
Clerk, right.
You know, people, you can make mistakes about, Smith may have died and Jones comes in and nobody knows it. As long as it's going to the secretary of the board or the president, a chief
Or
executive
the
officer,
clerk.
or the clerk, then
Right.
you're fine.
Municipal clerk, right.
And it
Okay.
really doesn't matter how it gets there under State versus Lee, any way you want.
I would tend to agree with you there, but it has to get to the right person.
And if there's a question about that, what we have is a question of fact, which we had in State versus Lee, and it went back down. Actually, it was going to be a jury question.
Well, wait a second. Are you contending that one of the recipients was the right person? I thought you were contending that you had reason to believe it was the right person,
Well-
but it turned out to be wrong.
Correct.
Okay.
But the notice of claim was addressed to the clerk, to the secretary, and then it had the wrong name, but it was to the secretary. In a situation like that, what's the receptionist, secretary, or whoever receives it, mail clerk going to do if you mail it? Going to give it to the secretary, because that's who it's supposed to go to. If I may reserve my remaining time? Thank you.
Thank you, Mr. Abney. Counsel.
Morning, Your Honors, and may it please the Court. My name is Jeffrey Harris, and I represent Maricopa County Municipal Water Conservation District Number 1. I'd like to jump immediately to a question that was asked. This is an H3 case. Under ARS 482901, all irrigation districts organized under the laws of the state are declared to be municipal corporations for all purposes.
But you, in your briefing, you indulge, Mr. Abney, your colleague, on H4 as well, don't you?
That's correct, Your Honor. We do discuss H4 as well, and the purpose for that is even if we're looking at this under H4, we still don't get there, and I can describe that as well.
Okay, but let's focus on 3.
So I don't think there's any dispute here that the clerk equals the secretary. To shed some further light on this, ARS 482971 states the officers of an irrigation district shall consist of a board of directors and a secretary appointed by the board. There are 5.
So who did the officers consist of? I mean, can you give us the actual name and title of who should have been served?
Henry Conklin was the current secretary that should have been served. Stan Ashby had been the secretary 2 years or longer prior to that. And the other individuals who were served, Glenn Vortherms was the general manager and Leighton Wolf was the president of the board. Now, even if we're going under an H4 understanding of this doctrine, under both Falcon and Batty, that's not sufficient because you can't serve one member of the board. You have to serve the entire board. as the
But
chief.
in the real world, there's no serious contention that the district wasn't fully aware of this notice of claim in a timely fashion, right?
Your Honor,
We're just arguing the strict compliance requirement.
The record's unclear on that. It was the very last day. It was served on March 2nd, 2018. So within the 180 days, I don't know. The record doesn't elucidate whether or not they had that knowledge within that certain amount of time. And I would like to clarify a couple of the assertions that have been made. I don't think it is clear as appellant has stated, that was a district representative that twice made this representation. If we go to the index record 11, this is the response to the motion to dismiss that was filed. We have 3 different pieces of sworn testimony: Exhibit 1, Exhibit 3, and Exhibit 4. Exhibit 1 comes from Attorney Burnett, who handled this case below, and he makes representations that it was a district representative. However, he doesn't swear under oath that he had any personal knowledge of that, and as such...
Well, how about your colleague's argument? I don't know if you're familiar with the Amazing Karnak. We used to have
Yes.
this Johnny Carson.
Yes.
How does your adversary or your colleague or someone that wants to sue you find out who to tell, I'm going to sue you?
I think there's 2 different considerations to that. One is the process you have to go through, and the second is where the onus falls. The first being where you find that information. It would be in the official board meeting minutes that are kept. You could have done a FOIA request and gotten that information.
So you need to do a FOIA request to sue your client?
Not necessarily. Mr. Wolf, who's the president, and Mr. Vortherms were both served, and there's no sworn testimony that they were even asked the question. What we have is that there was a non-supervisory, potentially a non-supervisory employee, and we don't even concede that because we don't know the identity of the individual.
Does your client have a website?
Yes, Your Honor, and I don't...
I'm sure
well,
it's popular, but does it list its officers and...
Candidly, Your Honor, I don't know that there's a website that lists this information. I'm not going to take the position it's extraordinarily easy to find. But then the question becomes, does the onus fall on the district or does it fall on the claimant? And as stated before, this individual, let's go to the Exhibit 3, which is the affidavit of Angie Rodriguez. She was the individual who served process. She was the one who states that she had personal knowledge of her interactions on February 27th or 28th and March 2nd at the district office. In paragraph 10, she states, on March 2nd, 2018, I returned to the MWD offices, meaning the district, where Sandy Del Real, the office receptionist, advised me that she could accept service of the notice of claim for Mr. Ashby. Now, there's no dispute Mr. Ashby was not currently the secretary, and interestingly here, she would have an opportunity...
What about the clerk? Was he the clerk?
I think we both agree, meaning appellant and appellee. I haven't seen any dispute in the briefs. The secretary is, for all intents and purposes, the clerk. Mr. Ashby was not the secretary at the time or the clerk at the time, though. And she could have stated that she served the secretary. She did not. Now, the notice of claim itself is directed to Stan Ashby and 2 other individuals. I think it actually would have been better to not have stated a name and just have stated the clerk or the secretary for the district.
Would we be here if we returned less specific?
There could be potentially an issue of fact on that basis, but it would depend on what the trial court found below. And this court case law has found that this court has to defer to the trial court's findings, even if they're clearly erroneous on an issue of equitable estoppel.
Well, but this is a motion to dismiss.
Right, but it is treated as...
We're totally de novo at this point.
Correct. That's correct.
So how do we defer to some finding of fact on a motion to dismiss?
Well, generally, this court will treat a motion to dismiss or a motion for summary judgment on a de novo review. The ideas of... Well, I would like to clarify from what I've found in the case...
The difference we have on a 12B is to your client's complaint.
Right.
Your colleague's complaint.
Right. However, there is case law that states that equitable estoppel, issues of equitable estoppel, there's a deference to the trial court. In the
trial court wasn't in a position here to even consider any disputes on equitable estoppel. It would be nearly impossible to consider equitable estoppel on a motion to dismiss.
Well, there were attachments that were made to the motion to dismiss and the response, and so the motion to dismiss was treated as a motion for summary judgment.
And should it have been?
Yes, it should have been. There was no exclusion of those exhibits by the court, and so the court treated that evidence. John C. Lincoln...
But if this is a motion for summary judgment, the court still doesn't have the ability to make factual findings that we defer to. All the court does in that instance is determine whether there is a dispute or not.
Right, Your Honor.
So there is no way that we could be here in this posture and be sitting deferentially.
All that I would state is what I've found in the case law. This is from John C. Lincoln in 2004 from this court. It states, "We defer to the trial court with respect to any factual findings explicitly or implicitly made, affirming them so long as they're not clearly erroneous as regards to estoppel matters, even if substantial conflicting evidence exists."
Was there any 56D motion filed by Mr. Abney?
No. No. There was just a motion to dismiss, a response, and a reply. Your Honors, the notice of claim statute, it's been, as we're very well aware, strictly construed for the past 25 years. This language has been in place since 1994. The Arizona Supreme Court has itself stated that actual notice and substantial compliance don't excuse a failure to comply with the statutory requirements.
I understand that, but I'm intrigued by a comment you made, which you hadn't made, which is that if they hadn't used a name, they might be better off. If they just said, "We served the secretary," good enough? And then you say, well, the person who got it wasn't the secretary, but at that point, who cares? They served the office of the secretary.
Your Honor, what I would say is under Levy State, which has been cited to by appellant, it is correct that mailing can potentially be sufficient. I don't think there's any way I can get around that. However, it has to be correctly addressed. Even Lee itself states that it needs to be correctly addressed. Here it was not. It was sent to a former board member. And if we're going to rule on this and vacate it, what we would have is potential former board members, potential former school members who could be served. And
was it sent to that board member at the district offices?
Yes.
Okay. So I'm a little confused then as to why it is that if you put the wrong name down with the right title, you lose. And if you put no name down and it goes to the exact same person, you potentially win.
Your Honor, the case law on this is a little confusing. There's a strict compliance that's necessary, but it has to be correctly addressed. There's no evidence on the record that it was a district representative, first of all, who informed the appellant or their process server that Stan Ashby was the correct individual. Regardless of this, the letter was addressed to Stan Ashby and it was mailed to him. Now, perhaps there could be a question of fact of whether or not it was mailed timely, and that has been answered.
If it had just said clerk, you lose, or you don't prevail at this point, you concede that?
I think there's no dispute that the clerk is the secretary. As we've looked at the list of statutes, the secretary and the clerk have a similar function, and there isn't a clerk that we're aware of.
But is the critical point that there was a name of a person rather than clerk?
Well, there's a few critical points. One is that the process server's affidavit and her affidavit of service both state she's accepting service on behalf of Stan Ashby. There's no dispute, as we've said, Stan Ashby's not the secretary. She states in her affidavit of service that she accepted or gave process service to Sandy Del Real on behalf of Stan Ashby in Exhibit 4.
Let me ask you this. If a process server shows up at the district office and leaves with the receptionist an envelope that says clerk, water district, and nothing else, is that valid service?
The answer is I don't know, and that's an issue of first impression in the state of Arizona. But we're not there.
But following your reasoning, wouldn't it be valid service?
It potentially would be, Your Honor. I think the idea here is if you mail a letter to my brother instead of to me at my home address, is that letter going to get to me? No, it's going to go to my brother, and so it would have been
No, but if I mail a letter, I don't know if we're married, but let's say I'm trying to mail a letter to your wife, and I say spouse of, is that good enough?
Well, I don't know exactly if that would be enough. I don't think it is, because it does have to be to an individual and not to an office. So maybe I am stepping back a minute here. But in 12821.01a, what we find is that you have to file it with the individual or the individuals authorized to accept service, not the office. So in light of that, I would think you do have to have a name on it that states exactly who's it going to. Your Honors,
So I guess just to be clear, and kind
Yes.
of, if it said Secretary Ashby, or Ashby, comma, Secretary, would that have been enough because it at least identified the secretary with the wrong name?
I think it essentially did that.
So you have to have both? You kind of have to say the right name and the right office?
You could even have the name but not the office, I suppose. And these are all questions, of course, not me. It won't be me that'll answer it, it'll be this court. Those issues have not been decided yet. Those are other hypotheticals. And I think the easiest way to decide it is what happened here. What happened here was there's no dispute. It was addressed to the wrong individual, and it didn't get there.
Did it have the title?
It had the title following the name. The notice of claim on Exhibit 2 does
And what
have-
was the title that was given?
It was secretary.
Okay.
The moral of the story is don't do too much. Don't hire a process server. Just write something on an envelope, make sure it has the word clerk,
I don't
and
think...
move on.
Well, in light of what I just said, ARS 12821.01a does need to be directed to an individual or an individuals. Otherwise, it would have said to the office. So no, I do think enough has to be done to get it to the right person, the right individual, and not just, you can't mail a letter to the secretary and have that be sufficient. Now, as we can see from the sworn testimony of Ms. Rodriguez, she accepted service on behalf of Stan Ashby, and she states in Exhibit 4 that she served Stan Ashby through Sandy Del Real, who's the office receptionist. And it's interesting to note that Sandy Del Real has not been identified until March 2nd, 2018. So we really don't have any information regarding who the individual was on February 27th or February 28th. We would think if it's the same secretary working there in the same work week from a Thursday or a Tuesday to a Friday, she would have been identified the first time. This could have been a citizen who was not affiliated in any way with the district. And ruling on this on the facts we have now would open that opportunity for individuals to serve process on a governmental office by going to the lobby and finding anyone there and handing them an envelope or asking them information in regards to who to serve. The onus is on the claimant and not on the governmental office. The doctrines of equitable estoppel, tolling, and waiver don't apply in this situation. Equitable estoppel has generally been held when there's a formalistic, the word formalism has been used in the cases, affirmative act by a government employee, usually in a supervisory role. Here we have a verbal representation, if anything, made by a district employee who's not in a supervisory role. The cases have held in the past that an individual who was a city manager, for example, had sent repeated letters to a charity board who had relied on those letters and been found that equitable estoppel had applied. Here, there's no such formalistic thing. If perhaps the board meeting minutes had been correct, that could potentially also be a case where there could be a question of fact. There's no such indication here that the board meeting minutes were even researched by the appellant below. Further, waiver doesn't apply in any fashion. The cases that we've seen on waiver are cases in which the governmental entity that's being sued has waived the affirmative defense of a notice of claim timely served because they've failed to litigate the merits of the case. Sometimes for a year, sometimes for 3 years, sometimes for 4 years. And the cases require that it be raised immediately. Here, it was raised immediately. There were no depositions taken, no subpoenas issued, no written discovery. A motion to dismiss was filed on these grounds right out of the gate, and the affirmative defense wasn't waived. The third idea of equitable tolling is that courts have applied equitable tolling when extraordinary circumstances beyond a plaintiff's control made it, quote, impossible, end quote, to file the claims on time. That language is from McLeod, which is a Court of Appeals case from 2007. In that case, the court may be familiar with a certain confluence of events that was really terrible happened to the plaintiff's attorney. His mother passed away, his wife had open heart surgery, his sister passed away, and then the backup attorney that he'd hired to do the work of his claims while he had gallbladder surgery contracted tuberculosis, along with the backup attorney's entire family. A truly odd set of circumstances. Even in those circumstances, this court referred to that as, quote, garden variety claim of excusable neglect, end quote, and failed to or refused to apply the doctrine of equitable tolling. In doing so, the court noted generally a plaintiff's pro se status has been indicative of whether or not tolling should apply, as cases in which a plaintiff is represented, that counsel is held to understand and be presumptively aware of what legal recourse may be available. The courts have also found that these doctrines should be applied sparingly, and lest the exceptions swallow the rule.
Pretty darn sparing. I mean,
I agree.
I'm struggling to find one that was sparing enough for these documents to be applied.
Well, I agree, Your Honor, but as we look at equitable tolling, generally the distinction that the case was making in McLeod was that an attorney's own illness would not be sufficient unless incapacitating, and death in the family would not be considered. So in certain issues, they quoted cases from around the country where the attorney had a stroke and later passed on. I mean, they're truly terrible circumstances. There, equitable tolling was applied. It's applied a lot more generally when it's a pro se plaintiff who isn't aware of these items.
But fair to say, it was hard to find it on the website. Hasn't met the standard in any
I
case.
agree, Your Honor. I think it was difficult to find it on the website, but I don't think we're anywhere close to the case law that's been cited in the
Let me
past.
ask just one follow-up question because it came up earlier. Even if Mr. Conklin had actual notice of this before, timely, actual notice isn't enough under the statute, is
That's
it?
correct.
It has to be strict compliance and served on Mr. Conklin.
In Falcon v. Maricopa County, which was in 2006, decided en banc by the Arizona Supreme Court, they stated actual notice and substantial compliance don't excuse
So
the
even
failure
if we
to comply.
assume the actual notice, it still doesn't.
Correct.
What's the rationale behind that? I mean, this case sort of raises the classic tension between rigid adherence to a known law and justice. I'm not sure that the result you're arguing for is terribly fair. What's the rationale underlying the strict compliance?
I think there's two different hypotheticals we can imagine where this really would extend a tremendous disservice to all the governmental entities in the state of Arizona. One would be in a situation where a former board member is served. There's no dispute this was a former board member. Imagine that you serve voluntarily on a school board and 2 years after the fact of serving part-time voluntarily, you're handed an envelope you don't understand and you assume that everyone else on the school board received it. You could face liability personally.
So that wouldn't be substantial compliance. I mean, that's just flat non-compliance.
It would be non-compliance prior to Falcon and Batty. Here, the argument's being made that it was substantial compliance. One of the arguments being made is that the general manager equates as the chief executive officer. And under Falcon and Batty, which both rejected that analysis specifically as applied to a superintendent or as applied to one member of the Board of Supervisors, I don't think there's a fair argument for that. Your Honors, I see that my time is up. We'd request that the judgment below be affirmed and the district be awarded its costs. Thank you.
Thank you, counsel. Mr. Abney?
A couple of minor things, or maybe not. In the answering brief, I notice on page 10 that my colleague says the district's clerk is the board secretary, which he also said here. And on the next page, page 11, they say that service may be effected by delivering a copy to the district's CEO, secretary, or recording officer. So they're willing to have service accepted under either 4 or under 3. And to them, it doesn't seem to matter.
It's a waivable thing?
I don't know about, well,
Or,
yeah.
or I mean, we have
Maybe
we have
optional.
a rule.
Right.
You could, go ahead and serve any of us.
Yes, I think they're equitably estopped now. Yeah, it's sort of a waiver thing, but maybe it's just
Or
that both
what-
of them apply. I suppose that's possible.
Go ahead, sir.
The other thing was that the notice of claim was addressed to Stan Ashby, Board of Directors Secretary, had the full panoply there. I never understood this actual notice doesn't suffice. That's about the strangest statement I've ever seen out of the Supreme Court. How could it not suffice? If you deliver it to the office, maybe it's not correctly addressed, but it gets to where it's supposed to go. I'm not sure that that's what they envisioned when they said actual service. I think it was more like it sort of somebody comes across it accidentally, learns that, well, yeah, has been a notice of claim and picks it up, and then there's
But it is
service.
actual notice, and that's from the Supreme Court, really not ours to change, is it?
No, but you have a different avenue here of this document. If it got to Henry Conklin, if it was handed to the receptionist takes a second look at it and says, oh, this doesn't go to Ashby, this goes to the Board of Directors Secretary, and handed it to Conklin. You've got an attempt there to get it to the right person through the receptionist, through whoever's picking up documents and delivering it to where it's supposed to go, which where it's supposed to go is to the board of directors secretary. We don't know because we didn't have any chance to do any discovery. Was there a Rule 56D affidavit? No. I wasn't on the case then, so I don't get the blame for that one. But it would have been nice to have some discovery here, which is really how, in the end, of course, State versus Lee shook down that there was going to be a jury question, a special interrogatory to the jury on this particular issue.
But you didn't file it.
Pardon me, Your
You
Honor?
didn't file a 56D motion?
No.
Did you attach something to your response? Did you
About,
attach an exhibit to your response to the motion to dismiss?
I wasn't on the case at the time, but I think he attached his own affidavit and some other materials
Okay,
in support.
so-
So they made an effort.
Right. So it would have been nice in retrospect, but
Yes, so many things are. When you're up
Sure,
at the Court of
right.
Appeals, things are great in retrospect. And finally, I may conclude, and probably won't take my full time, although it'll come close. Since 1963, the rule in Arizona has been that liability is the rule and immunity the exception. The Arizona Stone versus Arizona Highway Commission case. And at the time, the Supreme Court said, well, we don't understand how this doctrine of sovereign immunity took root since our nation fought a bloody, terrible revolution to get rid of the sovereign. And so that the sovereign would not be held to be inviolate and not capable of making an error. And I think, and I submit, that you should strictly construe the statute, and in this case, in light of case law, which would allow such things as delivery by mail and delivery even by a non-process server. And with that, I cede my remaining seconds to the court. Thank you very much.
thank you both for your argument. We will take it under advisement, and we will be adjourned. Thanks.